My name is Richard August, and I'll be your host. Our guest is Charles Chaz Calenda, Republican candidate for Attorney General. Welcome back to State of the State.
Thanks for having me, Richard.
Why don't you tell our audience about yourself?
Well, Richard, I've been an attorney practicing now my 16th year in practice here in Rhode Island. For my first 12 years, I was a member of the Office of the Attorney General as a state prosecutor in the criminal division. Enjoyed tremendous amount of trial experience, exposure to all sorts of criminal issues while I was in that office. Enjoyed the job incredibly. I left the office in 2018 to join the law firm I'm currently with, Inman & Torgy, which is in Coventry. And I've been practicing criminal law, family law, and some civil litigation while I've been doing the private practice work. And in 2020, I decided I was going to throw my hat in the race and challenge our incumbent Attorney General for his seat.
So you were a prosecutor in the Attorney General's office for 12 years. Why do you want to go back?
Because I'm really disturbed with the way the office has been running. And I can't say it started under this administration, but it's certainly been worse. The political aspect of that office, the partisan political aspect of that office, has become so apparent with the election of Peter Neronha as the Attorney General. He made no secret about it. As soon as he was elected, he went on an interview with the Boston Globe and referred to himself as an activist Attorney General. He was going to be an activist Attorney General, and boy, he's made good on that. And as somebody who's, I spent the first 12 years in that office. You're making decisions on people's lives, particularly in a criminal realm, civil enforcement realm, where you can have tremendous amount of impact on what people's lives are going to look like going forward. Partisan politics have absolutely no place in that office. And I want to run for that office to try to take that partisan bend out of it. I want to make sure that the office's mission is fulfilled. That mission is to achieve justice for everybody that comes across that office. That includes the victims of crime. That includes the people of the state of Rhode Island. That includes even the defendants, criminal defendants who are charged with the crime. But that's without regard to politics, without regard to where they may come from, who they may know. And it's just something that office needs, because I saw it firsthand from the inside when I worked there. There are more considerations at play than just law and facts.
What do you think he meant when he said an activist Attorney General? What does that mean?
Well, if you look it up, activist is somebody who's advocating for something, pushing for certain issues. He's tried to be cute with his words lately by trying to walk that back by saying, well, activist means I'm just not going to just sit back and wait for cases to come to me. I'm going to go and get those cases. But I think we all know what he means. He's been very vocal on partisan issues. He's been up at the State House advocating for so-called common sense gun control bills. He's acting more like a legislator than he is a law enforcement agent, but that his job is to be the chief law enforcement agent for the state of Rhode Island, not to be a legislator, not to be the governor, and it's certainly not to advocate for policy. His job is to enforce the law and do it in an apolitical manner.
Now, in your 12 years in the Attorney General's office, you prosecuted many gun crimes, or gun violence, perhaps. The incumbent, as you said, Democrat Peter Neronha, is a strong advocate for more gun control, such as the banning of so-called assault weapons, magazines that hold more than 10 bullets, and he wants to centralize the issuance of concealed carry permits in the AG's office, as opposed to the present system that allows municipal police chiefs to issue. What is your position on gun control laws? Does Rhode Island need more laws?
On the issue of guns, Rhode Island does not need any more laws than they already have on the issue of guns. This is my opinion. The current gun laws, before the ones that they even passed the last session, current gun laws in Rhode Island, if you're illegally using a firearm in a crime of violence, there are mandatory minimum sentences that can be imposed if you're charged with certain of those offenses. For whatever reason, the AG's office tends to drop a lot of those charges. And you have Peter Neronha going on TV saying, I don't have the tools in my toolbox in order to fight this gun violence that I see on a daily basis. Well, that's just straight not true, Richard. He has plenty of tools in his toolbox to fight them. He's pushing an agenda that we see on a national level, and it's coming from the Democrat Party on a national level to try to make guns less available to anybody, even law-abiding citizens. I think the issue of, you brought up the issue of the centralizing the issuance of permits through his office. Clearly, that's the reason. The reason for that is because the Attorney General by law, under Rhode Island law, has a tremendous amount of discretion in issuing those permits, whereas the local authorities, it's pretty much a mandatory issue if you meet objective criteria. I think that issue is going to be taken care of one way or the other come this June when the United States Supreme Court rules on the Second Amendment case that's currently pending before them, because the same issues at stake there. In New York State, you have to show a need to get a permit to carry a firearm outside your home. That's what the standard is here in Rhode Island for an attorney general to issue a permit. In my opinion, the only need you should have to show is that you're a law-abiding citizen, you're not disqualified by any other statute or regulation that would make you a prohibited person, and that you have the want and need to defend yourself and the skills to be able to handle those firearms. So if I were to be elected the attorney general, if you meet those qualifications, the only need you have is in the Second Amendment.
And Section 22 of Article 1 of the state constitution.
Absolutely. It's, we have a stronger, I think we have a stronger counterpart word-wise in our state constitution than we do in the federal constitution.
Now, several years ago, Governor Raimondo signed into law the so-called red flag law that allows police to confiscate a citizen's firearms based on a complaint from anyone or an allegation that the person represents a threat to society. You've defended clients, I believe, who have had their firearms seized. Describe the law and what is your experience in this area? Is the red flag law working?
So the red flag law, I can see where people had the good intentions to try to keep firearms away from people who would be imminently dangerous. And that's the word that we need to focus on here, Richard, is imminent. Because the statute is written in such a way that it allows the Superior Court to take firearms from the hands of people who pose an imminent threat to themselves or other people by virtue of having access to firearms. What I've seen in my experience in handling these cases is that the imminency part of the law is being ignored. They're going back years for things that are non-disqualifying, non-criminal, and they're using them against people for whatever reason. I can't give you specific examples because the law, as you know, has a confidentiality requirement. So I can't talk about specific cases, but I can tell you that in my experience, I've seen the law abused against people who have no criminal record, nothing in their background that would suggest that they're dangerous or have posed any threat to themselves or others, but they look at, the police were sent to their house for maybe a welfare check, and they wanted them to get checked out. They checked out, no hospital stay, no mental health issues, and went home. And now the police are not only using the red flag laws against them, they're using that to deny them the ability to even purchase a firearm. Never mind have it in their possession. So you go to a federally licensed firearm dealer and you try to purchase a firearm, you got to do a state and federal background check. Most people pass their federal one because if not, they're not even going to bother most of the time. But the state and local ones, the police now feel empowered, based on these red flag laws and other issues of the same area, to use these things as menial as a welfare check that resulted in nothing, to deny the person the right to purchase a firearm, which we all know, based on the United States Supreme Court holding in Heller versus District of Columbia, that the right to possess and own a firearm in one's own home is a fundamental constitutional right. So I have some serious concerns with the red flag law as it relates to infringing on that fundamental constitutional right.
The law also contained a provision that the Rhode Island State Police would issue regulations for municipal police departments regarding the handling, care, and storage of firearms seized under red flag. And some of these firearms can be very valuable. I mean, they could go into someone's home who has a collection of antique firearms, some of whom might be worth $10,000 or $20,000 because of their rarity. Do you know whether they've issued those regulations?
I've asked, Richard, and I've never received an answer. I can tell you that the towns that I've dealt with that have issued, used some of these red flags laws. I've had no reason to doubt that they were using care and the utmost carefulness to make sure that that property was protected, but I haven't seen any regulations, and that's part of the law. And if they're going to publish regulations, they have to do it in a certain way, so the public is aware of them, that they're publicly available, and they can be looked at so people can understand what they are, and in this case, police departments can abide by them. Unfortunately, I'm not sure how that squares with another provision in the law, which basically gives the police department civil and criminal immunity for using this law. So if they don't follow these procedures, which I'm not even sure exist at this point, there's really no liability for them at this point. And the Attorney General's one of their roles is to make sure the law is enforced. That's the biggest role. And I don't see the Attorney General out there making sure that these regulations are being promulgated in a way that's consistent with state law. And that's the first thing he should be doing when it comes to this, because we're talking about somebody's fundamental constitutional rights that we're taking away in a case where the evidence many times is quite thin.
So you're saying that even if a police department seizes valuable personal property and it's lost or damaged, there's no liability associated with that under law as it's written?
The way I read that law, under the Extreme Risk Protection Order law, which is the red flag, there is civil and criminal immunity written into that law for local law enforcement departments who use that law. So I don't know how you get around that. Other than you'd have to make a case to a judge that this is beyond mere negligence or accident, that this was an intentional misconduct by a police department. And even then, I'm not sure that you'd be successful based on the way the law is written.
As Attorney General, would you order the state police to write those regulations and publish them?
I would certainly reach out to the colonel of the state police and say, where are those regulations? And if they still would not publish them, I would have standing as the chief law enforcement officer of the state of Rhode Island to file an action in the Superior Court to compel them to do that, because the law says they shall do it.
Another law that Governor McKee signed into a bill that he signed into law is known as the Safe Schools Act, that prohibits concealed carry permit holders from carrying on school grounds. There was already a law in the books that prohibited the possession of firearms on school grounds. Just before Christmas break last December, a note was found in a Barrington High School bathroom threatening a school shooting at the school. And immediately, a sophomore girl posted a petition on social media asking students to sign, demanding that they go to distance learning until the session was over. And then a warning was also posted on social media, in response to which several school districts went to distance learning. Let's avoid the obvious question of whether a mass shooter would post a warning as to when they're going to carry out their deed. But we had on this program a state representative, a retired teacher, who supported the Safe Schools Act, and she said criminals would not be deterred by the law. So I guess the question that is raised is, would you exercise prosecutorial discretion should a concealed carry permit holder be arrested and detained for carrying on school grounds?
Well, the Attorney General, as a criminal prosecutor, always has prosecutorial discretion. And every case is going to be individualized, is going to be scrutinized in a way that's individualized based on the facts and evidence available to you when it comes to it. The law prior to its change only prohibited people without a concealed carry permit from carrying on school grounds. So if they're saying, the state representative you've referred to is saying that they're not, criminals are not going to abide by the law, and I agree with that. They're not going to abide by those laws. No law is going to stop somebody from carrying out a crime they want to commit. Who are they trying to deter? Law-abiding gun owners who have gone through a rigorous process to get a concealed carry permit? You and I both know, Richard, that these permits are not just handed out in the state of Rhode Island. You have to go through incredible background checks, reference checks. They look at every part of your life. So if they're not trying to deter, if they're not going to be passing that law to deter criminals, I'm not sure what the purpose of passing an additional law to stop law-abiding citizens from carrying a firearm on school grounds to ostensibly protect themselves.
Let's move on to another topic. As you know, negotiations are taking place to merge the two largest hospitals in the state, Lifespan and Care New England. And two doctors, a primary care physician and a specialist, as well as State Senator Susan Sosnowski, have written op-eds in the Providence Journal opposing the merger. The Attorney General has to sign off on this deal. As Attorney General, would you support or oppose the merger of the two hospitals?
Well, as I'm sure you know, Richard, the statute that governs the Attorney General's authority on this is quite extensive. there are, and don't quote me on the number, but it's at least 25 subsections that of considerations that the Attorney General has to look at, in addition to what the Department of Health also has to look at, because they also have to sign off on the mergers as well. Most of those questions that I looked at were factual, objective criteria that the entities have to meet. And the Attorney General's job is to make sure that criteria is met, that there's evidence to prove that it's being met, and that there is some discretion to decide whether or not this is going to improve or not improve the access to health care in Rhode Island. I'm a big believer in, monopolies are not a good thing for anybody, particularly in healthcare where we have shortages right now. But I'd have to follow the law, and that's what I want to suggest is the most important part as his role in the Attorney General. Whatever he thinks of the law as it relates to his authority to oversee this, there are many objective criteria which, if are met, would somewhat compel him to sign off on this merger, despite public opinion. If they don't like the law, there's ways to change that law. They go to the State House, they go to the governor, they go to the Department of Health. The Department of Health actually has more discretionary authority than the Attorney General does in this particular case. And if the Department of Health was coming to me as the Attorney General and saying, we have serious concerns that this merger is going to keep people away from meaningful and useful health care in the state of Rhode Island, that is going to be something that would weigh on my mind more so than petitions or public outcry, because they're the ones who are supposed to be the subject matter experts in that. I'm looking at it from a legal point of view.
During the last year's hysteria over the COVID pandemic, the Secretary of State suspended the laws concerning absentee ballots and the requirement for witnesses or notarization of mail-in ballots. Mail-in ballots were a major factor in the 2nd Congressional District and several local elections, as you know. Now, bills have been filed in both houses of the legislature in this session that would make permanent the procedure that the Secretary of State instituted. 2 questions. First, why was Secretary Gorbea's rule not challenged? And second, do you support making her rules permanent law that essentially creates a voting season rather than election day?
So this is the exact reason I decided to jump in the race to challenge Peter Nerona for the Attorney General's office. It was because of his dereliction of duty for failure to go to federal court when the ACLU and the League of Women Voters sued the Secretary of State to remove the requirements of state law that required 2 witnesses and a notary for mail-in ballots. When that suit was filed, who is our chief law enforcement officer? It is the Attorney General of the state of Rhode Island. He should have been in court, whether he likes that law or not, should have been in federal court defending that law. He did not do it. Not only did he not defend it, he said nothing. So in other words, he allowed the Secretary of State, a federal court, and the ACLU and the League of Women Voters to enter into this federal consent decree. Federal consent decree, which essentially put aside state law requirements that you have those 2 witnesses and a notary, and allowed those ballots to be counted. The GOP did challenge that action in federal court. They went all the way up to the United States Supreme Court. And if I remember correctly, I think it was Justice Alito, and when they denied certiorari, which is a discretionary review by the United States Supreme Court, I believe it was Justice Alito who said the reason why we are doing this, or why they were not going to review the case, is because no state officer of the state of Rhode Island defended the law. And that, to me, is not only inexcusable as the Attorney General, in being the Attorney General of the state, it's unethical. You have left your client, the people of the state of Rhode Island, without representation in federal court. And you have now, by doing so, nullified a duly enacted law of this state. Like I said, I don't care if he agreed with it or hated it. It's his job to defend it. There's never been a ruling in this state, federal court or state court, that suggested that that law was in any way unconstitutional or unlawful. So he had an obligation at that point to defend state law.
When you're referring to Justice Alito, you're talking about the United States Supreme Court, not the Rhode Island Supreme Court.
That's right. This case made it for consideration all the way up to the United States Supreme Court, and the reason they didn't take it, unlike unlike the cases that came from some other states, I believe South Carolina was one of them, or it might have been Alabama, the reason they didn't take it was because nobody in the state of Rhode Island who holds a statewide office defended the law. And the person whose job it is to defend the law is the Attorney General, and he didn't do it.
First Governor Raimondo and now Governor McKee have exercised continuing declaration of emergency powers, ostensibly to protect the public from the coronavirus pandemic. And the emergency powers are limited by law. As Attorney General, would you challenge a governor who declares emergency authority on a continual basis?
I certainly wouldn't do it for partisan reasons. I certainly think that the Attorney General has the unique ability in the state of Rhode Island, being a constitutional officer, an independent constitutional officer. The Attorney General has the ability to be a check and balance on other branches, not necessarily branches, but even other actors within the state government. In this case, the Attorney General has failed to do so. Not only has he failed to do so, he's been the rubber stamp for all of it, because all the people who've been filing lawsuits, whether it be the mask and school mandates, whether it be the vaccine mandates, who's the one defending the state policies on this? It's the Attorney General and his army of 100 attorneys that work for him. These are the people that your taxpayer dollars are going out there and saying, you know, we don't have any problem with this ongoing state of emergency. We don't see any problem in declaring a new state of emergency after the General Assembly has already terminated the COVID state of emergency and declaring a new state of emergency based on a variant of the virus that's already out there. I think there were some serious problems. There remains some serious problems in the ongoing use of that. I think one of the biggest issues that the Attorney General should have been involved in is determining whether or not the statute that grants the governor that emergency authority could pass the non-delegation doctrine, which is a separation of powers issue. Because part of what makes the ability of the legislature able to delegate this essentially lawmaking duty to the governor, their duty to the governor, is that it passes the non-delegation doctrine. And there are several requirements for that to happen. One of which is that there are safeguards to prevent against administrative abuse. That was missing in this case. Because as you know, as part of these hundreds of executive orders that were issued over the last 2 years, the Department of Health was essentially making order after order under the emergency rules to put rules and regulations in place on an emergency basis that shut down businesses, that shut down schools, that took people out of their jobs, and that was unchecked, essentially unchecked. The courts didn't want to get involved. Some courts were saying it was a political issue. The Attorney General himself argued that this should not be reviewable by a court because it's a political issue and the courts have no business getting involved in that. To me, that's just another dereliction of duty by the Attorney General, who can be an effective check and balance. He could have gone in there and said, I've done my own independent review. I've done my own independent review of the state statute, the way it's being applied, the way the Department of Health is using it, the way the governor's using it. And I don't think it conforms with state law, our Constitution, or the United States Constitution. The Attorney General doesn't always have to agree with the governor and doesn't always have to defend the governor's actions. In fact, I think recently the Attorney General's come out and said one of the state agencies that there's a conflict of interest they're not going to defend it. There is an independent authority. The Attorney General doesn't work for the governor. The Attorney General doesn't work for any other state agency or any other state body. He works for the people. And I believe the Attorney General is the people's attorney, not just the government's attorney. There's certainly going to be times where the Attorney General has to defend government action because people sue the government left and right, and there's going to be times you're going to have to do that. But there is also a role to be a check and balance, and that's what we're desperately missing in the state.
Do you support issuing driver's licenses to people here illegally because either they've overstayed their visa or they've participated in the mass migration from Central America and Mexico? Should Rhode Island issue these people driver's licenses?
Well, that's a political question that our General Assembly and our governor are going to have to issue. My question about that is, how are we going to ensure these individuals are able to obtain insurance? You have to have insurance to drive a motor vehicle in this state. Most of insurance policy companies I know require credit-based scoring. Do these illegal immigrants have the ability to have that evaluated in the same way that you or and I would? Are they able to obtain a social security number? Are the IDs that they are going to be given going to contain hard stops, so if they do attempt to vote, for instance, that they will not be able to do so? If they are able to do that, then you have to leave it to our legislative officials to determine whether or not that's going to be a law. But I would need to see, as the Attorney General, I would like to see some safeguards in place if they are going to issue that, going to issue driver's licenses to illegal immigrants that ensure that they have to conform with other existing state laws.
As you know, that it seems likely that in this session of the legislature, there will be a bill passed to legalize the recreational use of marijuana. Where do you stand on that issue?
If you're asking me personally, I don't have a problem with that. I think there should be responsible use of it. If you're using it in the confines of your own home and you're doing it away from other people in a safe manner, that's fine. What I have a problem is you get behind the wheel of a car, or you endanger other people by your use of recreational drugs. That's where I'm going to have a big problem with it. But again, that's not something I'm going to be out there advocating for or against as the Attorney General. I will say that I was against the legalization of all these other hard drugs, actually not even all of them, one in particular, fentanyl, considering the opioid crisis that we've got going on right now. The Attorney General vigorously advocated to minimize the penalties, from felony penalties to misdemeanor penalties.
For fentanyl?
For including fentanyl. Up to 10 grams of fentanyl is now a misdemeanor to possess. Do you know what 10 grams of fentanyl can do? You don't have to use it. You don't have to be an active user of it. It's absorbed through your skin. If you absorb even a gram of fentanyl through your skin, you're gonna die. If you expose people in the air to 10 grams of fentanyl, you could kill a small city. It's like having a chemical weapon. I'm all for giving people second chances who have drug addictions, putting them into alternative programs so they don't have felony convictions. I am not for putting other people in danger by simply changing the law to make it less severe to have that amount of a drug like fentanyl, which you don't have to be an active user to affect other people with.
It's pretty amazing. I hadn't heard that side of the argument before. As you said, the office has 100 attorneys and obviously other support personnel. Would you have any idea about, and because if you had 12 years experience already, about reorganizing that office in any way? Or
structurally, there are a lot of things I'd like to change about that office. There's a lot of good people who work in that office who are not affected by the day-to-day partisan politics that go on in the upper echelons of that office. And we need to make sure that that office maintains its talent and their ability and the expertise to have people who know how to try cases. And unfortunately, they've lost a lot of people who have that experience over the last few years. So there are a lot of ways I'd like to restructure it, particularly the screening unit, which is the unit that evaluates whether or not a felony case should be prosecuted in the Superior Court. There's a lot of things that can be done with that unit to make sure cases are properly screened, to make sure that only cases where there's a reasonable chance of success go to the Superior Court, and you weed out the rest of them. Because it's a lot of money to defend yourself against felony charges. I don't think it's being utilized properly in this case. That's one example of maybe how I would structure it. And I'd also give people who are entering that office at the beginning entry levels experience in different areas of the office for longer periods of time before you move them to the Superior Court trial calendar, so they have that experience when they get there and are able to effectively advocate the positions of the Office of the Attorney General.
would you be willing to come on and debate Attorney General Noronha later on in the election cycle?
Absolutely, and I absolutely would make that known right now that I would welcome the debate with Attorney General Peter Noronha to discuss the role of the Attorney General and how we both see that office going into the future.
We want to thank you, Attorney Charles Calenda, for coming on State of the State. We are indeed in a political year now in Rhode Island, and we would look forward to having Attorney General Peter Noronha here to debate Attorney Chaz Calenda. Thank you for watching State of the State.